So Crawford versus Washington fundamentally changes the way we understand the confrontation clause. As we talked about in the last video, there is an added layer, an added requirement for the prosecution to show if it seeks to use something that's otherwise hearsay against a defendant in a criminal case. This is the Sixth Amendment's confrontation clause requirement in the federal Constitution, but it's one of those requirements from your con law days that you will recall has been incorporated against the states, and therefore the states also have to comply with it, much like the Fourth Amendment, the Fifth Amendment, et cetera, et cetera. So Crawford versus Washington raises a question that had seemed pretty well settled up until this point. If there is a hearsay exception, what are the circumstances under which that is sufficient to satisfy the confrontation clause and allow something that is hearsay to come in against a criminal defendant? And in Ohio versus Roberts, as we talked about in the last tape, the court had said, so long as this is a well-regarded exception, or if it's a new exception, as in like not 200 years old, and the stuff looks particularly reliable, then it comes in. Well, Crawford versus Washington fundamentally changes all that. So let's lay the facts out first, so you get a sense of how this actually works. So in this case, Michael Crawford is accused of stabbing a man. He stabbed him supposedly because the victim, Lee, had tried to rape his wife. So after the stabbing, the police, they go interview Michael and Sylvia Crawford, Sylvia being Michael's wife, and they both provide statements. Well, Michael Crawford says he thinks he saw something, some kind of weapon, in the hands of the victim, Lee. Sylvia Crawford, they interview her, and they want to offer her statement because there's at least something in Sylvia Crawford's statement that looks like there was no weapon in the victim Lee's hands. So the question then becomes whether her statement can come in. I mean, it's not a polar opposite statement of her husband's, but we're not looking at how valuable the evidence is. We're looking at whether it satisfies both the hearsay exception and then the confrontation clause. Well, the hearsay exception that's satisfied here is, and the part of the opinion I've given you doesn't really go well or thoroughly into this, that this is offered as a statement by the state of Washington that's against her interest, that her entire statement shows that she was involved, that she kind of egged on her husband's stabbing of Lee, and therefore her statement in its totality is a statement against her penal interest. It shows her being a part of a conspiracy to stab Lee. So there's your hearsay exception. But what about the confrontation clause? What criteria does it have to establish? Now, the Washington Supreme Court had said this also satisfies the confrontation clause because this looks particularly trustworthy. There are things that corroborate this statement, et cetera, et cetera. Well, Justice Scalia uses this opinion, and for those who are critics of Justice Scalia, this is one of the cases that they point to show that how his use of originalism has really done some real odd things to the law. For decades, for almost a century, we had a fairly good sense of what the confrontation clause meant, and then this fundamentally changes it. Justice Rehnquist, another fellow conservative, was very critical of Scalia in this opinion, in Rehnquist's dissent. What Scalia says is, look, if you look at what the framers thought, and this like a lot of these originalism arguments are very debatable, and so on the basis of some kind of unclear history, Scalia is going to fundamentally change the way we think about criminal justice, or did change the way we think about criminal justice. In this opinion, he says, if you look at what the framers were worried about, they weren't worried about reliability. They were worried about procedure, that they were worried about the ability of a witness to cross-examine those people who were making things that look like depositions, those things that look like statements that are being made in anticipation of trial. And he talks about a couple of historical treason trials, the trial of Sir Walter Raleigh and others, where the prosecution had obtained a written statement from the Crown witness, and then that statement never appeared, that witness never appeared to be cross-examined at the trial itself. And so Scalia says, look, it's not about reliability, it's about the right to cross-examine, that you cannot exempt the state from subjecting their testimony to cross-examination just because the statement looks reliable. What is it that will exempt the statement from being cross-examined? When does a hearsay exception also qualify as a confrontation clause exception? Scalia says that the confrontation clause requires cross-examination whenever a statement that was made by a witness who's now not subject to cross-examination, whenever that statement was made in anticipation of litigation. So if you prepared this for the police, if you prepared this for the prosecutor, if when you wrote out or gave an oral statement that was recorded somehow, or even has been reported back, if you gave that statement and it would appear to a reasonable person making that statement that the purpose for which the statement is being collected is to use in a prosecution at some point, then that statement cannot be used unless the witness is there to be cross-examined upon it. So again, Crawford fundamentally changes the confrontation clause's limitation on hearsay rule exceptions. So in order to bring in a statement against a defendant in a criminal case, step one, you've got to show that there was a hearsay exception under the rule of evidence, either federal or the state analog that we're relying upon. Then additionally, under Crawford, you have to show that the statement that the government is attempting to bring in against the criminal defendant is not a statement that was made reasonably in anticipation of litigation.